All right, well, our attendee count is shooting skywards. We're up over 50. Thank you all for joining us. This is an exciting joint federal practice CLE luncheon sponsored by the Tampa Bay Bankruptcy Bar Association and the Tampa Bay chapter of the Federal Bar Association. We haven't done many joint events, but one of the things that the leadership of both bar associations is looking forward to doing in this new year is trying to do more joint events, and we're really excited and happy to see so many of you here joining us for this federal practice CLE luncheon. I'm Eric Johansson. I'm a member of both the Federal Bar Association and the Tampa Bay Bankruptcy Bar Association. Angelina Lim is my co-chair at the Tampa Bay Bankruptcy Bar. We put together these CLE lunches, and we have with us an esteemed judicial panel that's being moderated by Dana Robbins and Lara Fernandez. What I'd like to do just at the outset is kick it over to Jordan Majelich, who's the president of the Tampa Bay chapter of the Federal Bar, and Noel Boki, who's the president of the Tampa Bay Bankruptcy Bar, to make some initial remarks on behalf of the bar associations. Then we'll introduce our judicial panel and get on with the program.
Thanks, Eric. So I'll keep it short and sweet. As Eric said, I'm Jordan Majelich. I'm the current president of the Tampa Bay chapter of the Federal Bar Association. Just want to express my appreciation to the folks that made this possible. FBA is really excited to collaborate with the Tampa Bay Bankruptcy Bar Association, and we hope this is the first of many events in the future. And I'll turn it over to Noel.
Thank you, Jordan, and thank you to you, Jordan, your team, and the Federal Bar Association for co-sponsoring today. And thank you to Lara and Dana and our all-star panel of judges who will be speaking today remotely. We had hoped to be back in person, but COVID has yet again changed our plans. Kind of reminds me of my days in the Navy: start, stop, hurry up, wait. That's what we seem to be doing. So our next CLE, February 8th, will be virtual. The view from the bench, which was scheduled to go down here in Tampa next week, that has also been postponed due to COVID. It's rescheduled for May. The reception will be May 11th at the Vault in downtown Tampa, and the seminar will continue at the Camels facility on May 12th. If you have already signed up, your registration just continues right through. You're good to go. You don't have to do anything. But if you can't make it, you can request a refund online, and Nicole Knoll will do that refund for you. The Florida Bar mid-year meetings, including the business section meetings, which were scheduled for January 26th and January 27th. They will continue, but they will now be virtual. They will not be in person anymore. We still have hope, though. We're still optimists, and we hope to have more in-person events in February. February 4th is Judge Gentleman's portrait hanging ceremony in Orlando at 4 o'clock. That is still scheduled to go live and in person. And earlier that day at 0800, the TBBA, we have a clay shoot scheduled. It'll be outside. So if you're really ambitious, you can do both. Shoot shotguns in the morning and go watch the portrait hanging, watch art that afternoon on February 4th. February 25th is Judge Vaughn's investiture in Tampa. That is still planned to be conducted here in person. Judge Delano on March 8th. She will be conducting the March CLE, her State of the District presentation. She still plans that to be live and in person at the U Club here in Tampa. The annual Judge Pasquet ABR Stetson seminar is still scheduled live downtown Tampa at the Marriott Water Street Hotel, March 29th through March 31st. And we'll have our annual Judge Glenn golf tournament on April 22nd. So keep your fingers crossed for those live events to occur. From Judge McEwen, she has a few announcements. There is a free seminar series called Behind the Bench, which is put on by the National Conference of Bankruptcy Judges. That kicks off this Friday. It's a free CLE event. You can sign up at ncbj.org. And then finally, Judge McEwen's next quarterly brown bag mentoring CLE lunch on talking tax will be on March 3rd. So thank you very much. I'll kick it back over to Dana.
Thanks, Noel. Appreciate the updates. And what I'm going to do is go ahead and kick it over to Dana and Lara, who are our esteemed moderators. Just some very brief introductions. Lara Fernandez is a shareholder at Trenum Law. She's board certified in business bankruptcy. She's a member of both the TBBBA and the FBA. She's recognized on all the lists, best lawyers in America, legal elite, super lawyers, all that good stuff. Dana Robbins, our other moderator, she's an attorney at Burr & Foreman. She's a former, most importantly, she's a former law clerk to Chief Bankruptcy Judge Delano, and she's recognized as a super lawyers, rising stars, up-and-comer. They're going to be moderating our program, which of course is the reason you all are here, to see Judge Delano, Chief Judge Delano, from the U.S. Bankruptcy Court, U.S. District Judge Mary Scriven, and Magistrate Judge Anthony Porcelli. We're so grateful to have you all here. So what I'm going to do is get out of the way. I'll move Noel and Jordan out to the attendee room, and thank you all for being here and look forward to the program.
Thank you, Eric. Good morning or good afternoon, everyone. My name is Dana Robbins. I am the bankruptcy co-chair for the Federal Bar Association. Now, before we begin with our substantive agenda, in light of the continuing impact of COVID-19 and most recently, the Omicron variant, Judge Delano and Judge Scriven, can you please advise the participants here today of any recent updates or changes in the bankruptcy court and in the district court?
I'll go ahead and start first, if that's all right with you, Judge Scriven. Before we started, I made the remark that it seems like Groundhog Day, and every single day for going on 2 years now, the judges of our courts have had to deal with COVID issues. And I just feel the pain, I think, of all the lawyers, because your lives are much more difficult than our lives. Our lives have, definitely been complicated, but your lives are much more complicated. So at this point, it's pretty much more of the same. As you probably all know, the Tampa bankruptcy judges continue to hold most hearings by Zoom and by telephone, but we'll all schedule in-person trials if that's appropriate. Judge McEwen's courtroom is always open to any attorney or party who'd like to appear in person, and posted on her webpage on our court's website is information regarding appearances in her court. I did want to give you one update that has been a little bit deferred because of the Omicron variant. We are currently in the process of revising our form notices of hearings to allow the judge to select whether the hearing will be solely in person, solely by telephone or by Zoom, or whether people are welcome to come into the courtroom. Based upon the increase in COVID cases in the last couple of weeks, I've kind of backburnered that for a couple of days. But be on the lookout for those changes in the hearing notices. When those are finalized and ready to be used, we will send out a CMECF email blast so everyone will know that the courtrooms are open for business. We would encourage everyone to take stock of themselves before they come to the courthouse. We've had numbers of individuals, not high numbers, but literally every day we hear about someone who works in the courthouse, including among our own staff, who's been diagnosed as positive. So if you don't feel well, please don't come to the courthouse. If you have a reason to be concerned about your health, maybe you want to continue to appear by Zoom and by telephone. So Judge Scriven, I'll defer to you.
Good afternoon, everyone, and thanks for having me participate on your program. It's always good to talk to the bankruptcy bar and get you filled in on what happens in the district court in case you accidentally come to the wrong floor when you come into the building. With respect to COVID, we are still on the watch, I guess is the best way to look at it. Judge Corrigan, the chief judge of the court, recently, I believe on January 3rd, issued the following sort of indication that because of the striking number of new cases in the district, and based upon the recommendation of our epidemiologists and the COVID committee, of which I am the chair, we're recommending that the judges pause in any jury trials, in-person jury trials in the district. And that is for the month of January. It is a strain of the virus that thankfully is not as virulent as the Delta and the original strain, but it is nonetheless making people sick, and it's very contagious. And so that was his recommendation, and most of the judges have canceled or postponed all jury trials, because jury trials, require us to bring in 50, sometimes more people into the courtroom at any one time. And it's hard to manage a sterile environment in that circumstance. And so that's what people are doing. So you'll see cases get continued, and that's why that's happening. You'll see yourself being sent to the 17th floor to try a case when it does come off in person, because that is the largest courtroom, and it's where we can social distance people. So you'll see more Zoom hearings. You'll see even on the criminal cases, initial appearances being held by the magistrate judges via Zoom. And that's how we're going to operate. And we'll take a look. The epidemiologists and all the models suggest that this variant is going to drop off a cliff toward the end of January, and then we'll be able to start moving back in person again. And so from my mouth to God's ear is all I can say about that. Thank you.
Thank you, Judge Scriven. Now, an entire program could be committed to the impacts of COVID-19. What would you say are the key impacts COVID-19 protocols had on jury and non-jury trials so far?
With respect to that question, I think that it's obvious that we've had to shorten our trial docket and limit the number of cases that we can try, because they have to be socially distanced. Criminal trials have to be in large courtrooms, and there's really only one very large courtroom that can accommodate more than a one defendant case. So we've had to shorten in terms of the number of cases we can try. We've had to extend trial jury selection to different times, and we've had to move to Zoom. I've had a Zoom trial, which was very fascinating. You can read all about it on our intranet site. And if anybody wants to talk to me offline, I'm happy to talk to you about it, but it was quite an undertaking. Apparently in the state of Washington, they've tried jury trials by Zoom, which is interesting because they're doing it without the consent of the parties. It's been a wild ride because people don't know how to behave when they're on Zoom, because they don't know that we can see them, I guess, when their faces in the screen. You've heard all of the tragedies that we've had, but I've had people log in with really bad names as their login name. Check your login name before you sign in. I've had witnesses appear in the bed with their head on a pillow. Please don't do that. Just behave as if you were in the courtroom, and that's dressing from head to toe, not from head to waist, in case you might have to stand up.
Thank you, Judge Scriven. Judge Delano or Judge Porcelli, do you have anything to add?
Let me just add quickly. What I think has really been interesting is the Zoom technology and the impact upon our court. And I expect that to last for quite a while. We've learned that Zoom trials, and as you know, the bankruptcy court only conducts bench trials, but we've learned that Zoom trials can be very effective. And even when everyone is coming back to the courthouse and appearing in person, considering the cost and expense of bringing out-of-state witnesses to a trial, and they have to sit in the courtroom all day and wait until they're called, or that sometimes they have to sit in the hall all day and wait until they're called into the courtroom, it may very well be that we all get used to a new normal, which is that out-of-town and out-of-state witnesses appear by Zoom in almost all cases. So it's very cost-effective. It's something for you all to be thinking about. I'm personally very grateful for the Zoom technology. I expect it'll just get better and better as time goes by. And I think all of the judges think that the gold standard is attorneys in court, but I found it to be very effective, certainly with motion practice. To me, it really doesn't make too great of a difference whether the attorneys are in the courtroom or if they're appearing by Zoom. So let's just see what happens over the next couple of years. I'll echo Judge Scriven's comments about parties' behavior and demeanor and dress while they're appearing by Zoom. I am aware of 2 incidents, one of which occurred in a case of mine, and another one which occurred in one of my colleagues' cases, where an attorney was so annoyed by the ruling that the attorney, turned his back to the camera, was gesticulating. That's awkward. That's not a good idea. And I have never had anyone appear from in the bed, but I have seen plenty of beds in the background. And if you need to appear by Zoom from your bedroom or a hotel bedroom, I would strongly suggest you use a virtual background because it just detracts from the entire experience. Doesn't make that much of a difference to me, doesn't affect the way I rule on the case, but it's not a good habit to get into.
And I will just say, first, I want to thank everybody for the invitation to participate in the joint program. It's always a pleasure to interact with the bankruptcy bar as I get little opportunity to do so. I will say the first time I was invited years ago to do an ESI presentation, I quickly learned the bankruptcy bar is by far one of the most collegial bars out there, which is always appreciated by any judge. And I could certainly say, which is probably not a little known secret, but we've got some of the best bankruptcy judges in the nation here. But beyond being just smart, they're some of the funnest people in the world. So it's always a pleasure to be part of any joint program. As to your answer, I'll just do a couple things. The first is I'm going to check myself. I am fully dressed. I want to make sure that's on the record. The second thing is I agree with Judge Delano. When you ask about what the impact is, the reality of it is there will be a new normal. And I think even those that are what I would say diehard as far as the old ways as being in person will still adopt some of these new procedures. I've said this many times and I really believe it. In the end, it's put a lot of pressure on the lawyers because it's just not about being Clarence Darrow anymore. You've got to be Martin Scorsese and Steve Jobs all at the same time. You've got to know the technology that's being utilized. You've got to understand and appreciate on how you're presenting yourself on the video because it's a vastly different presentation. And you still have to effectively advocate for your case and your client. So there are a lot more expectations of the lawyers than what we have previously thought of in prior proceedings. We're all still adapting to it. But I still think, and I agree with Judge Delano, that even whatever happens with the pandemic, some of these technologies will be utilized because they're cost effective and should be embraced going forward.
Thank you, Judge Porcelli. We have divided the program into pretrial issues and trial issues. So we're going to move forward with our pretrial topics now. Judge Porcelli, can you please explain your overall outlook on discovery and your expectations for a proper Rule 26F conference?
Well, the overall outlook on discovery, when you ask a magistrate judge like that, I'm sure you could expect certain answers, but in the end, I will give you my sense of, for those who don't know my background and experience before I took the bench, my practice was largely as a prosecutor. And so I had little experience in civil discovery. In criminal discovery, through the rules of procedure, just as the civil rules themselves are to operate, everything is self-executed. But obviously, I quickly learned in civil practice that is not the expectation. From the court standpoint, there should be little need for court intervention. The rules are clearly defined. If the parties operate accordingly and properly under the rules, then there should be rarely the circumstance that the court is required to be part of the process. However, we all know that is being naive if that is the expectation. In reality, the court needs to be involved, and the 2015 amendments expressly recognizes that the court should consider being an active participant in the management of the case early and as soon as possible. It starts in the beginning of any case, and I want to emphasize my comments in that I'm not here to say that one size fits all. I recognize there are different types of cases, and even the rules recognize proportionality as to the needs of the case. So the lawyers themselves are going to be in the best position to ascertain how much effort and what should entail the 26F conference. But there are some basic principles that I think lawyers should expect going in. First, electronic discovery will be involved with your case. Simple as that anymore. That needs to be the expectation that it is the exception now that the case does not involve the ESI. And if that is the case, you need to be well-versed as to where is the evidence stored and what capacity is it stored and who are the relevant custodians. When you go to a 26F conference, that should be on the forefront of your mind as to what you're going to do to address any of those issues, to include the form of discovery, the timeliness of the discovery, and whether there is going to be any preservation issues. One thing I emphasize all the time when I'm asked that question is, in the end, our court does predominantly everything on the paper. But I would encourage the parties that if you think the court can aid in that early process in formulating your discovery plan, you should request to conduct a hearing. Either it will be referred to the magistrate judge or the district court will handle the matter itself. But I highly encourage the parties to do that if they think there are going to be problems. My view is the parties that do a very thorough 26F conference, the parties that I never see, because they've thought these issues out. They've addressed them early on. And that's really what you are as a lawyer, particularly in a litigation, if you're trying to get just to the merits of the cases, to be problem avoiders rather than creating problems. And the best way to avoid the problem is anticipate it early on by looking at your case and evaluating those issues as soon as possible.
Thank you, Judge Porcelli. You briefly touched on preservation of electronically stored information. Can you please give us the court's view on preservation of electronically stored information and any ESI protocols that you would recommend?
So let me start off with preservation, which I would suggest is probably one of the most difficult things for a party and a lawyer to address. And the reason for that is it's a matter of when the triggering mechanism occurs as to when there is a duty to preserve. Obviously, if litigation's filed, that's a no-brainer, and anyone's going to recognize that there is a duty to preserve. It is the pre-suit triggering that it can be difficult. And then it makes it very difficult for you to advise your client as to what is the necessary information to be preserved. I think one of the most fundamental things to appreciate in this context is reasonableness. Anytime that you're having to defend your preservation, the court is going to do determination whether you acted reasonably. So first and foremost is identifying what may be at issue, and then communicating it appropriately to those that are necessary to make sure that they are properly preserving the evidence that is necessary to the litigation. And again, from my prism, the majority of that is going to be electronically stored evidence. So if you have routine deletion policies, to make sure those are suspended so you're properly preserving the information. Preservation letter obviously is fundamental, but it's not just having a letter, it is what's the content of that letter and who it is communicated to. But as to the expectations of preservation, if you could demonstrate that you acted reasonably, I think then that you should be comfortable in going forward. But again, you can't put your head in the sand. If there is an obvious trigger that there is a duty to preserve, you need to make sure that you're aware of that and that your client is aware of that. As to your question about protocols, I've actually changed over the years as to my philosophy on ESI protocols. I think protocols are helpful and certainly important, but my view has changed a little bit because the technology has changed. I think there needs to be a real appreciation, especially now more than ever, on how quickly the technology is changing, and look at whatever protocols you're using because they may be obsolete. So as I'll give you an example, the concept of a custodian can be very different now than just 2 years ago. The court uses now predominantly Microsoft Office 365, which is predominantly cloud computing. We have Microsoft Teams, where we are sharing documents with one another. And I know that is now just one of many platforms that is being adopted in the business world. And so the concept of just having someone act as a custodian on their own server or on an entity server is now a little bit obsolete. Who is an actual custodian when you're on a team? Who manages the team? And so when you think of terms of preservation, and if you have a protocol as to preservation for necessary custodians, that may not capture, for example, the concept of teams. And so I think you really, again, when you think about protocols, it starts foremost in meeting with your client and understanding their IT infrastructure before you really start adopting certain protocols. But before you even get to the protocols themselves, I think there needs to be a robust conversation at that 26F conference. So there's a true appreciation. One size does not fit all. So I'm not saying you need to provide and hire a vendor to help you each time, but in certain cases, it's almost a necessity to seek outside expert help to help you navigate those waters. But it starts with your client, who's going to know their IT infrastructure better than anyone. So if you start with them and get an understanding and appreciation of what they have and where it's stored, then you can start forming your protocols for the case.
Thank you, Judge. Now, you've touched on preservation and the duty to preserve. How often are you seeing Rule 37E motions related to spoliation of evidence? And Judge Scriven, I believe you have an opinion, Swafford versus Esslinger, 671 Fed Sup 2nd, 1274, Middle District of Florida from 2009 that addresses this. If you could speak about the facts of that case.
Yeah, that was an interesting case and involved an individual who lived next door to an area where there have been a number of car thefts and such, and the police were on the lookout for the potential perpetrators, and in this instance came upon Mr. Swafford in his own backyard, and allegedly believing that his 6'9" or 11-inch frame was that of the short Hispanic males. He was a big, tall, white guy. They unloaded their weapons and shot him, I think, 7 times, and then stepped over him and made comments on the course of doing so. And he survived, and he heard the police officer's comments and the circumstances. And then he sued them. And in the course of suing them, because he had incidentally won the Florida lottery, he had money. And so he hired a very seasoned law firm, and the law firm sued the police and then sent a preservation letter. And the young lawyer who worked internal to the police department, in-house counsel, apparently had never seen a preservation letter and had not, he said, read the rules of procedure since he took the exam. And so he didn't know what he was supposed to do, and they proceeded to destroy all of the evidence. Their theory being that that evidence was destroyed in the normal course of their destructive practices, including the weapons, the clothing they were wearing, and all of the email strings. And what happened was someone sent an email to another police officer in another police department, something like lotto killer is the word that they use in the context of that email. And that email made its way to the public light. And then the question became whether all of the emails that were destroyed would have revealed harmful information to the police department. And because the court concluded that it would have, based upon the content of the one email that existed and all of the evidence that had been destroyed, I did not rule that the plaintiff could prevail, but I did order that the jury could be read, given an adverse inference, take an adverse inference from the destruction. And once an adverse inference can be taken from the destruction, it's very hard for the person defending that behavior to overcome it, because the jury is allowed to make certain assumptions and they ultimately resolve the case. But that's how it came to be. And so I'd say, with all of that backdrop, it's so important that you follow a preservation letter. If someone serves you a preservation letter, just follow the preservation letter. That is not anything that requires a lot of thought and a lot of discussion. The issue becomes in our daily walk that people use their business issued devices for personal comments and content and use. And so you have to send that word out to all of your individuals who are involved, that they have a duty of preservation as well, which was not followed in this circumstance either. So I think it becomes an issue. It's not often an issue, but it's enough of one to know to stay out of the waters on it. And that's to just follow protocol, read the rules and follow the rules. And then your clients don't have to come to you to get them out of trouble because you've kept them from getting into trouble in the first place.
Thank you, Judge Scriven. Now, Judge Delano, I believe Judge Williamson has an opinion in Ray Electronic Machinery Enterprises, Inc., and that's 416 BR 801 that also addresses this issue. Would you like to speak with that?
Yes, please. Thank you, Dana. So Judge Williamson's Electric Machinery Enterprises case is very well known to bankruptcy practitioners. And if you're not a bankruptcy practitioner today, when you hear the expression EME, please know that the other person who's talking to you is talking about the Electric Machinery Enterprises case. Many, many issues came up in that case, and one was the issue of spoliation. The case involved a dispute between the debtor, who was an electrical subcontractor, and the general contractor on the construction of the Orange County Convention Center. And the evidence was that the general contractor, after a dispute had arisen with the electrical subcontractor, the debtor, that the general contractor or an employee of the general contractor had tossed documents relating to the construction project and a hard drive relating to the construction project into a dumpster. So the debtor came screaming into court with a complaint seeking a preliminary injunction, which Judge Williamson did grant. But the issue of spoliation came up in the context of the trial of the claim itself. So Judge Williamson's opinion includes just a great discussion of the applicability of spoliation standards and the imposition of an adverse inference if it's appropriate. In this case, Judge Williamson determined that the sanctions were not appropriate because at the time of the spoliation, the general contractor was not under Florida law under a duty to preserve evidence. But, and the judge Williamson also held that because the debtor had been able to prove his case, that none of the destroyed documents were actually critical to the case. And so the judge did not find it appropriate, Judge Williamson did not find it appropriate to award sanctions. So many issues in the EME case, and I would definitely recommend it. It's a thorough exposition of law in Florida in the 11th Circuit regarding spoliation, damages, and adverse inferences.
Dana, I'd like to answer your first question about how often does this happen. Well, first, let me just say, I loathe this issue because this is a matter that is collateral to the case. And it is a costly endeavor and a time-consuming endeavor. Typically, every time this matter has come up before me, it puts a standstill on the underlying merits of the case. The parties get bogged down in the expenses, and it becomes much larger than anticipated. I just want to caution a couple of reminders on certain things. The first is the rule, as far as the rule of procedure changed in 2015. To this day, I still see lawyers citing to pre-case law from 2015. The standard is if there was the duty to preserve, that the information is no longer available. And if you're seeking specific sanctions, which I would call the drastic sanctions, that there was a specific intent to deprive the requesting party of the information sought. Rule 37E applies only to electronically stored information. And so if you're not talking about electronically stored information, then you can move forward under the common law. The other thing I want to caution is to the lawyers, a reminder of Rule 26G, which is a certification by their signature on any production. They are certifying that there was a reasonable inquiry for the production and that the production is complete. Lawyers all too often forget about the importance of that because in the end, they are certified that the production was done appropriately. And what that means is if it's later demonstrated that it was not done appropriately, lawyers themselves can be sanctioned for the inadequate production.
I had a question, and it's only because I don't appear in district court as often as I obviously appear in bankruptcy court, but would this issue be before Your Honor or Judge Scriven, or it depends? Or, I mean, I don't think I just was wondering as a practical matter.
So, Judge, if you don't mind, I'll jump in first on that. The answer to that is it depends. It will vary. The district court can send it to the magistrate judge, which I would say is the most common process. But if I'm to recommend what I would call, for example, the most drastic sanction, which is dismissal, it would be done on a report and recommendation. So Rule 37E, there are still some, I think, issues to be decided eventually. So for example, the first possible sanctions are those non-drastic sanctions. I am of the belief that I could issue an order on those sanctions rather than a report and recommendation, and that the standard of proof is just simply a preponderance standard. There's case law that supports, as to for the drastic sanctions under E2, that it is a standard of clear and convincing, because you're talking about the culpability of the producing party, that their state of mind was to deprive the requesting party of the ESI. Those are more dispositive sanctions, and therefore I'm of the belief that that requires a report and recommendation. But more often, these issues are going to come before the magistrate judge first, then for the district court's consideration. But at times, the district court may just take it upon themselves to resolve them.
I think that's right. I can tell you that one of the things that I would add to the cautions that Judge Porcelli gave is that this is not something you should assert lightly, because you're really saying someone has done something inappropriate. It's not, you didn't produce discovery on time, or you're not thorough enough. You're saying that a person destroyed documents with the intent to deprive you of the importance of that discovery. And so really, it shouldn't be something that you do all the time. And so in the main, I will allow the normal issue of who gets to resolve it to be handled by our normal processes, and it will go to the magistrate judge most of the times. Sometimes when the issue is so hotly contested, or it's on the eve of trial that it's finally asserted itself, I'll take it up, because that cuts off the time for the magistrate judge to do a report recommendation and the time for the parties to object to the report and recommendation, and then for me to rule. I can just take it up and rule from on a one briefing schedule basis, and so I will. But in the main, the magistrate judge is going to take the first crack at the resolution of these issues.
For the benefit of our bankruptcy practitioners, you probably are aware that in 2019, the bankruptcy court adopted Local Rule 7026-2, which is itself adapted from the e-discovery rules of the Middle District Civil Discovery Handbook. So there's some minor variations, just made applicable more to bankruptcy cases than to other district court litigation. But if you're dealing with e-discovery, you do want to take a look at our local rule.
Thank you. And I just want to remind our participants today, our chat box is open. So to the extent that you have any questions that you'd like to pose that are topically relevant to what we're talking about, you can put them in the chat box and we will address them in turn. Okay, so we've discussed the preservation of ESI, the potential consequences of failing to do so. With respect to discovery production issues, what are the key reoccurring issues raised in motions to compel? Judge Porcelli, I think that this might be appropriately addressed to you. Boilerplate objections, proportionality issues, undue burden, if you can comment on that.
So you've already addressed some of my answers right away, but yes, one of the main things, again, not to harp on the amendments, but they were designed specifically to avoid some of these issues, but we still are routinely seeing these issues in discovery disputes. And the one example is boilerplate objections. So I'm here to let everyone know, and if you don't want to take my word for it, just look at all the recent cases by the magistrate judges in our district and then any other district. Boilerplate objections simply will not be accepted anymore. And if that's all you're asserting, the objections are going to be deemed waived and you're going to have to produce. You have to specifically identify your objection, the basis for it. That next issue is now, which has become a catchphrase in discovery practice, is proportionality. One common objection that I'm seeing all too often is the discovery is not proportional to the needs of the case. And that may very well be, but you have to state it with specificity. You can't just simply assert the objection. And you have to identify then, why is it not proportional to the needs of the case? And I promise you, 99% of the time that issue comes up before me, there is no factual basis for the proportionality objection, and then it's later just withdrawn. And so if there's really no basis for it, then why is it being asserted? I don't want to give the impression that that means all the discovery disputes are not meritorious. That's quite the contrary. All too often, the ones that I hear and resolve, there is merit to it. But I think if the parties, and this is the one failing I see, which is I appreciate you all are busy and there's a lot on your plate. But the one thing I see all too often is in the end, it's the lawyers are not communicating with one another. I know you don't want to have to come before me or any other judge to resolve any particular issue. And if what happens is by the time I schedule a hearing to resolve the matter, that's what's prompted the lawyers to talk to one another and the issue goes away. And so it seems to me we're wasting a lot of time just by failing to communicate with one another, by picking up the phone and talking to each other, because these issues always percolate through email and miscommunication. And then someone files a motion. And then when I schedule the hearing for the motion, I get a call later saying, Judge, we resolved the issue. Or if I have a hearing, at the hearing, I'm told we've discussed it and we resolved the issue, which I greatly appreciate. I'm here, so it doesn't matter, but I think it's a matter of wasting your own time to have to file the motion. So that is one thing that is, to this day, always been a constant, persistent problem, is the failure to effectively communicate with one another.
And let me just add something that has always surprised me. I can't tell you how many times I've had a hearing on a discovery motion, and my first question to the lawyers is, have you had a chance to talk with each other about this? And they shake their heads no. I've had attorneys waiting for me to enter the courtroom, sitting on opposite sides of the courtroom, not talking to each other until I came into the courtroom. When that happens, I usually send the lawyers into the hall, or I tell the parties we'll come back in 10 or 15 minutes. You all pick up the phone and call. And now that we know how to send people to separate Zoom rooms, we might put the lawyers in a separate Zoom room. But this lack of communication is just totally frustrating, because I try to prepare for every hearing. I know Judge Porcelli prepares for every hearing. And to think that the lawyers haven't bothered to speak to each other prior to the hearing, particularly when the big rules require the parties to meet and confer, our local rules require the parties to meet and confer. The parties need to meet and confer because usually they can distill the issues down to one or two issues that maybe they can't come to an agreement on, but they start off with a whole laundry list. And frankly, the judge can easily be, lose track of the forest for the trees, just trying to figure out what is the most relevant objection or the most relevant issue.
And if you do have those meaningful meet and confers, as Judge Delano was saying, you're really narrowing the issues, and more importantly, it will help you focus in on what arguments you need to present. And they need to be supported. So as I stated, the proportionality objection, that needs to be supported. If you're asserting a burden objection, that needs to be supported. You can't just simply assert it and then think that your argument at the hearing is going to win the day. There needs to be a factual basis in support of those objections for the court to rely upon to sustain your objection. So I think that's those are the really common mistakes that I see, is really the failure to narrow and communicate and then have sufficient support for your objection.
Right. And sometimes I'm sorry, go ahead.
I would add, as a common issue that I see, and I saw as a magistrate judge, and I still see as a district judge, is that once discovery disputes sort of percolate, the parties are annoyed with one another. And so what I see most often in a motion to compel has more to do with your annoyance with the other side than what the substantive issue of the motion is. So I call it the wine without the cheese. It's, he did this and she did this and they didn't give me this and they didn't give me that. And I sent 3 emails and see all my emails with all the nasty back and forth. And in the end of the day, my question is, what is it that you want? What does the law say you're entitled to? And how do you want me to provide relief? Those are the only 3 things that should be in your motion. This is what I want. This is what the law says I'm entitled to. And judge, here's how I want you to write that order. Do it in the wherefore clause. I can cut and paste it from my laundry room, office, Zoom room, whatever I'm doing at home. I can cut and paste it, put it in an order and send it back to you. If you don't tell me the relief you're seeking and how you want me to give it to you, then you're going to file a motion for reconsideration or motion for modification because I haven't given you exactly what you want the way you want it. And secondly, I really like Judge Porcelli and Judge Sansoni and Judge Sneed and Judge Tude and Judge Flynn. And so when you object to an order that they have entered or R&R that they have provided for me, it should not begin with telling me how mean and horrible and ignorant and stupid they are. that does not carry any weight with me at all. I know all of them are seasoned judges. They know what they're doing. And so although they sometimes get reversed, you should not start with, Judge Porcelli had no understanding of the salient issues of ESI and he's mistaken about this. Just tell me what you want and tell me why you think that there was a legal error under the proper standard, because that's the only way you get anywhere with an objection from a magistrate judge, R&R, or an order.
I want the record to know that she said she really liked me first. And go ahead, Judge Delano, I'm sorry.
Well, just to follow up on both what Judge Porcelli and Judge Scriven just had to say, I think the annoyance factor is huge. And where that annoyance factor comes in is when the parties are conferring with each other by email and in writing. And maybe they're showing off for their clients, or maybe they want to get, progressively snottier with each other. But that's what I see in the progression of those emails and letters. And really, what the parties should want to do, or what the attorneys should want to do, is head the dispute off at the pass. Get on the phone, get on a Zoom call, talk with each other, and see if you can work these things out. Because what I see in the demand letters and the responses is a lot of posturing that really doesn't accomplish anything for anybody. And, Judge Scriven just talked about not appreciating it when there's, criticism of the magistrate judge. I will say, and I'll say this on behalf of all of our judges, when the lawyers are just butting heads, it is so frustrating and it's so detracting from the legal issues. So pick up the phone, talk with each other. One thing that our bankruptcy bar is especially known for is the camaraderie and the collegiality. And for the most part, the attorneys are able to work with each other and work these issues out. But every once in a while, there's just, a clash of the titans. And, you'd think it's World War III. And we're talking about a document production request. It's not really enough to fight over. The parties should be saving their energies for the legal issues in the underlying case, not spending it all on discovery issues.
And Judge Delano brings up an interesting point. Lawyers can fight with each other, and we get that, but lawyers shouldn't be fighting with pro se litigants. They don't know what they're doing in the main. They don't understand the procedure. They don't understand the way to do things. And so casting aspersions on a pro se litigant is like a law professor doing the Socratic method. It doesn't serve any value to you. Just ask for what you want. Treat these litigants with respect. I know that sometimes they are trying because they don't understand what they're saying or doing, but there's no need for the lawyers to get into that level of the fray. Just say, respectfully to Mr. So-and-so or Ms. So-and-so, the law does not provide for this relief that they are seeking. They don't have standing, they can't sue for their mother or their father, but you should have it at a higher level and don't devolve into the method and means by which pro se litigants carry their cases. And I will say, especially for bankruptcy lawyers, when it gets to an appeal before the district court from a pro se, long protracted matter, we need a good record. And if you devolve into the process of a pro se litigant, you'll destroy your record and give them actually more standing to pursue an appeal than they might have had you stuck with the law and the standards.
Thank you, Judge Scriven and Judge Delano. Those are very helpful, practical tips on how to deal with discovery disputes and practitioners. And Judge McEwen did just chime in on the chat that it makes the judge's life a lot easier, particularly when dealing with pro se litigants, if you deal with them with respect and professionalism. So, and preserving.
What she said was, "Amen, Judge Scriven." Read out loud.
Okay, so now we're moving along on our pretrial topics, and we have a deposition. Now, Judge Delano, in bankruptcy court, we have a local rule that allows for discovery-related issues such as depositions to be raised informally to the court. Can you please explain under what circumstances that would be appropriate to invoke that local rule and contact chambers, and what, if any, information is needed for you to make a determination?
Sure, thanks, Dana. So we talked a moment ago about meeting and conferring, and both our local rules 7026-1, which relates to discovery, and 7001-1, which relates to adversary proceedings, they both have meet and confer requirements prior to filing a discovery motion. Under Rule 7001-1, which I mentioned only specifically applies to adversary proceedings, but perhaps it will be broadened. And I think an attorney in a contested matter in the bankruptcy case, such as an objection to a claim, something along those lines, or evaluation motion, the attorney could use the provisions of 7001-1. In this case, I'm referring to 7000-1J. But under that provision, if the parties can't resolve a dispute, any party can request a telephone conference with the court so that the court can render an informal preliminary ruling on the discovery dispute, which would be without prejudice to the right of any party to file a formal motion. So in my experience, these requests are usually infrequent, and they usually arise during a deposition. As a matter of fact, seeing Judge Scriven here reminds me of the time that Judge Scriven's husband, Lance Scriven, called me in the middle of a deposition to resolve a dispute. So if I'm available, I always take the call, and I believe all of my colleagues do the same. I know that Judge Williamson usually has his law clerk, Ed Comey, screening those calls. But if I'm available, I will take the call. When these discovery disputes arise during a deposition, I would say it has 100% of the time been in connection with a case with which I am very, very familiar. So I don't need to know any background. I already know how much the lawyers aren't getting along, and I know about the millions of dollars they're fighting over, and how this particular witness is a critical witness to the case. But I do usually like to take a few moments to take a quick look at the docket. And if I'm not familiar with the case, so if you were to be calling me on a case that's just sort of below my radar screen and I haven't had much involvement with it, what I need to know is, of course, who the witness is. And I always give the examining attorney the opportunity to explain what the dispute is, and the opposing attorney has an opportunity to respond. I don't think I've ever spent more than 5 or 6 minutes on one of these calls. They're on the record. The court reporter is taking everything down. Those calls have never come back to me. In other words, no one's ever said, "Oh, Judge, you gave us this preliminary ruling, but this is why, you should have ruled differently." They've never come back to me. And it just sort of helps sometimes with the flow of the deposition. So that's something to think about. All of our judges welcome those calls if necessary. You do have to realize, if you make that call and I'm busy doing other things, I have to sort of refocus myself and figure out, just what's going on. So you have to be, I think, a little patient with the judge under those circumstances, because the judge might have been involved in hearings that day, or, really is distracted by other matters. But I think it's really helpful. We also encourage attorneys to ask for a telephone or a Zoom conference if there's a dispute outside of a deposition that could be resolved by the judge's ruling on a very discrete issue. So when this would come up would typically be in a document production request. So our thinking process when we adopted this rule was that the attorneys go to a lot of work to prepare motions to compel and responses to motions to compel. And there's requirements in terms of what's required to be in the motions to compel. And we spend a lot of time just trying to, winnow through a motion to compel and figure out what's going on. Because speaking of boilerplate objections, we see boilerplate definitions. So on a document production request that's maybe 19 pages long, the documents that are requested, items requests 1 through 9, are all on one page. It was 18 pages of boilerplate that I have to page through on my screen to get to the meat of what the request is. But if you have that kind of an issue that's come up, you're not in the middle of a deposition. We don't need to schedule it that minute. We can schedule it in a day or two or a couple of days when everybody is available. And that way the judge will have had a chance to take a look at the docket, take a look at the document production request. If it's not filed on the docket and you're not supposed to be filing discovery, papers on the docket, but many people do. If it's not on the docket, then you need to email those papers to the courtroom staff, to the chamber staff, so that I or a judge on the case would have a chance to take a look at it. But I found those to be helpful. It hasn't come up very often, but it really will save a lot of time and a lot of attorney's fees for the parties if it's a specific issue that doesn't take a lot of court time, and the parties can just work it out and the judge can give a preliminary ruling. Our philosophy in the bankruptcy court generally is that the parties need to know what direction they need to head in. And usually when they know that direction, they can work things out on their own, but they need to have some indication of what the judge's thinking is. And so I think using that procedure will be very helpful to all of our attorneys.
Now, Judge Scriven and Judge Porcelli, is there a similar procedure in district court? Are parties allowed to contact chambers, or if so, under what circumstances would that be appropriate?
You're on mute.
And in front of the district judge, you really have to look at each judge's preferences. Sometimes those are set out on their web page within our website, and you can ask. I don't mind lawyers calling chambers to ask short questions like, does the judge want us to bring all of our exhibits to the pretrial conference, or will we be able to patch one of our lawyers in by phone call? But don't call chambers for substantive reasons and expect my law clerks to provide an answer to a legal question. We just aren't equipped to do that. If there is an emergency, I have gotten circumstances where someone's child is suddenly ill, or someone, something's happened, especially in COVID, and I will take those calls and we'll cancel a hearing. You don't have to go through all the rigmarole of filing something, and we'll get that on the record. But you just have to be circumspect about calling the judge for substantive issues. And if you call the judge for any issue, please be courteous to staff, because they will report not only the substance of what you asked me, but the tenor of what you asked me. And yes, I know your motion is pending, and yes, I know how long it's been pending. We keep a running record in chamber of all the motions and when they're pending. And so I'm aware of it. Yes, I know your summary judgment motion is pending, so you don't have to call and ask those types of questions. We are aware of it. And I think lawyers get anxious and annoyed, and they kind of push that off on the court. So it's not typically appropriate to call chambers other than for technical problems and limited issues. We don't have a procedure in district court for you to ask for a telephonic hearing on a motion to dismiss right away because we need an answer. That's just not.
Well, we don't do that either, just so you know.
But I did hold hearings as a magistrate judge. I would hold, somebody call me. I had someone call me in the middle of a deposition where the deposition notice said it was to occur from day to day until completed. And it was Friday, and Saturday was a Jewish holiday. And the lawyer wanted me to make the people stay there on Saturday because it said day to day until complete. And that didn't happen. And it was not a very pleasant entry into the video deposition by the magistrate judge at that time.
Well, I will echo what Judge Delano said a moment ago, that it is a rarity. I'm sure it has happened in my 12 years now on the bench, but I just can't recall off the top of my head that I would have gotten a phone call during a deposition in a case that I was not more than familiar with. I typically am anticipating at times when that may occur. But I welcome it. One of the things I often tell the lawyers, though, is as you're working through a deposition, is to continue with the deposition, set aside what issues you have, and then as you get near the completion of it, then contact me. That way I can resolve all issues that have come up during the deposition at once, instead of getting a call periodically throughout the day. I've often at times too, when I've anticipated problematic depositions, have made my courtroom available and had the parties come conduct the deposition in my courtroom. And if necessary, I can just get right on the bench and resolve the issues. That's been a rarity, but that has happened before. As far as contacting chambers, You know, as judges, we make a lot of decisions. I'm more than happy to say the best decisions I've ever made are the people I've hired for my chambers. They're all fantastic and very helpful. And I welcome you if you've got issues that we can help with. But more importantly, though, as Judge Scriven stated, do not contact chambers about substantive issues. We're not going to be giving advice in any way or discuss any substantive matters. But if you have questions as to procedures or questions about whether, even at times I get this often, that after I schedule a hearing, you have a conflict. Well, I would invite you to call if you have a conflict rather than going through the problem of filing a motion. But before you do that, confer with opposing counsel and make sure you've got other dates that you want to propose for my consideration. I will accommodate the best I can any dates for a suggested hearing. But the one thing I do want to emphasize what Judge Scriven stated a moment ago is, and I think everybody knows this, and it goes without saying, but I do want to emphasize it. The Middle District of Florida is one of the busiest districts in the country. And that is just a fact. If you look at our numbers and the amount of workload that we do, given the amount of judges that are on the bench, one thing that I'm proud of is how we manage this very busy docket. I think we manage it very effectively to get the work out in a timely fashion. As to discovery disputes, I will tell you every day, I look at my daily report. As soon as I see a motion that is related to discovery, I'm reviewing it with a cursory review and making an initial determination. For those that have had cases in front of me, you probably have seen it very often, either the day after or no more than 2 days later. I'm either scheduling that for a hearing or doing something with the motion because I'm looking to keep it moving along the best I can. Sometimes some of these discovery disputes get very large and take more time to resolve. And so, but I will stay attentive to them to move them along. But for the most part, it is my, and as well as my colleagues, I know for sure, it is our goal to resolve these as soon as possible for you, as Judge Delano said, so you have an idea of the direction of the case to go forward with the litigation.
Thank you, Judge Porcelli. So we're going to transition now into some trial issues and topics that come up, and I'm going to turn it over to Lara Fernandez.
Thank you, Dana. Okay, so all the lawyers have now been in front of each of your judges with respect to all their outstanding discovery, motions to compel, depositions. You thoroughly are annoyed with all of them, and we go to trial. So, Judge, the first question, Judge Delano, is actually pre-COVID, I think the bankruptcy court is very advanced on having exhibits be electronic. So maybe you could kind of go through that process. Do you like a hybrid? Let's do like kind of pre-COVID and COVID. And pre-COVID, did you like a hybrid? Kind of what are your soft spots for that?
Okay, sure. So we have a local rule, and all of our bankruptcy practitioners, I hope you're familiar with this. If you're not, there is something wrong. But we have a local rule 9070-1 that explains our procedures for uploading electronic exhibits. And this local rule is really the brainchild of Judge Williamson. So I'll give a little hint out to all of the non-bankruptcy practitioners. When I mentioned a few moments ago, when you hear EME, we're talking about electric machinery enterprises. When you hear fundamental, you'll think, oh, something's fundamental. Lots of things are fundamental. It's fundamental. Oh, no. If anyone in our court says anything about fundamental, they're talking about fundamental home health care, which is a huge case that Judge Williamson has had these many years. In any event, fundamental was the fundamental case was the impetus for our local rule, essentially, which is there were thousands of exhibits, and how were they going to be managed? And Judge Williamson had a process where the exhibits would be put on a thumb drive or a disk and then brought to court, and then the attorneys could use them, look at them on computers, et cetera. Well, we have a crackerjack IT staff, and the crackerjack IT staff figured out how to store all of our exhibits electronically in a way that doesn't impede or slow down CMECF, so it's just huge. Well, it's been a game changer for our trials, because in the olden days, what would happen is the lawyers would come for trial. They would each have 6, 9, or 10-inch binders full of their hundreds of exhibits. At the end of the trial, I would realize, oh yeah, out of the 200 exhibits on that exhibit list, only 35 were offered into evidence. So meanwhile, I have a crook in my neck because I'm pulling these binders on and off the bench, just absolutely a nightmare. So once the exhibits are uploaded, it's wonderful. It saves trees, it saves 9-inch binders, and it saves paralegal time putting all these binders together. And what happens is the lawyers bring to court with them, pre-COVID times, just a small binder or a small folder of the individual exhibits that they intend to offer into evidence with respect to a particular witness. So if they have witness John Smith, they have a small binder of the exhibits for John Smith. They also have a courtesy copy for the judge so the judge can keep track of what's going on. You know when you're going to trial what exhibits you're going to offer into evidence, or you should know. But most lawyers are just, what's the word I want to use? Paranoid, neurotic. They're just afraid there's some document out there they might need. And so they tell their paralegal to go ahead and prepare an exhibit list and exhibit binders of every single document that's been used in the case from day one. And so sometimes we have multiple copies of documents because there's exhibits to interrogatory responses or document production requests or deposition exhibits. So, you know, they're in there several times. In any event, what lawyers' number one worry when we went to this electronic upload process was, their number one worry was, what if they don't have an exhibit in a binder that they do want to offer into evidence, so they don't have a particular exhibit for a witness? Well, they're not prejudiced. They can still offer that exhibit into evidence. They might need to provide a paper copy. Half the time, my staff is happy to print out a paper copy for them. It's just not a big deal. The other big advantage is that under our local rules, the parties need to exchange their exhibits in advance of the trial. I think it's 7 days prior to trial. Well, guess what? If they upload them electronically, that counts as the exchange. So it's a time saver for attorneys. You know, there is some work on their part of their paralegal staff in terms of uploading the documents, but at the end of the day, it's just such a huge saving of resources, and it makes the trials go a lot smoother. So Lara's question is, what happens now in the COVID times? I think if you have a question, you need to talk to the judge, or not to the judge, but to the judge's staff. Make a call to chambers. You know, Judge Scriven used as the example, does the judge want me to bring my exhibits to the courtroom? And I think it's just going to depend upon the case. If it's a short trial, and unlike the district court, probably we have many short evidentiary trials. You know, maybe it's a 2-hour hearing on valuation of a home. Well, there's really only 2 exhibits I'm interested in, and that's the appraisal reports that are hopefully not going to be introduced into evidence, but are going to be identified and from which the appraisers are going to testify. I want to look at the color copies of those appraisal reports. So the attorney should have uploaded color copies of the appraisal reports so that we can see the comp sales in color and we have a better idea of what's going on. I don't need paper copies of the appraisal reports. If I want to look at one particular page, I'll print out that one page myself. So it really is going to depend on the trial. And if you're doing the trial completely by Zoom, I think you just need to check with the judge's chambers and see, you know, how the judge wants to handle that. I have really been amazed at how well trials can go with the screen share function, and attorneys are just remarkably adept at using the screen share function to have witnesses review exhibits and to offer them into evidence. And that, I think, has been really helpful.
Thank you, Judge Delano. Judge Scriven, how is it going on in the district court? Do you have this advanced? I feel like bankruptcy court's very advanced with the electronic exhibits. Do you kind of have the same protocol? And what is your preference?
I think it depends on the judge that you're in front of, what his or her preference is. And that's another thing you need to understand before you go into the courtroom, what the judge's preference is. My preference is for the lawyers to upload all of their exhibits electronically so that I have an electronic folder of the exhibits. The parties still bring me binders and binders, and they sit over here to my left of the bench, never to be touched during the course of the trial. So pull them up electronically. work with my staff ahead of time and have the documents available. But to Judge Delano's point, my experience is the smartest thing lawyers can do with exhibits is have a key exhibit notebook. Just the 30 or 40 documents you're going to use time and time again, and they don't have to be in numerical order. They can be exhibit number 35. Everybody knows when exhibit 35 is getting ready to be called up and we all go, oh my gosh, here we go again with exhibit 35. Just have those key documents available for presentation, easily accessible to the court in paper and electronically if you want, and then you can move through your case really quickly. Stipulating in advance of trial to the admissibility of documents is also a huge time saver. You're going to get your documents in unless somebody scratched them on the back of a notebook on their way to the courthouse. I mean, the authenticity is hard to challenge. If there's going to be a hearsay issue, it's a hearsay issue. But if it's just business records and they're going to be able to call a records custodian for their admissibility, just stipulate to the admissibility of the documents and get on with the matter of trying your case. And then you don't have to stop with, I want to show you exhibit A. Is this the true and correct copy? And was this prepared in the ordinary course of business? And is it the ordinary course of business to prepare such document? Just get the documents and the evidence and let the trial go forward, especially a jury trial, because the jurors are easily distracted by that ongoing process. With respect to COVID, I will tell you, if it's a evidentiary hearing, it is often appropriate, I think, for the lawyers to ship the old school way, or either electronically, if you have an electronically savvy witness, the exhibits you intend to introduce through that witness. So they will have a notebook in front of them at their home or their home office that they can turn to, because if they're going to have to authenticate a document, you need them to have it in their hand. Not a lot of people have the technological savvy to be a witness and an IT person simultaneously. They're already nervous, they're already out of their element, and then you're asking them to, okay, I want you to turn on your Zoom screen to so-and-so, and I'm gonna share this, and they're confused. It's just easier to send them either by electronic in advance of the hearing or by a notebook in advance of the hearing so they can turn to them in the normal course, because it's a lot to ask a witness, a lay witness, to do your electronic piece as well as their testimony piece simultaneously. So I would encourage that practice, even in the highly technical world that we're living in the world of COVID. There's a lot going on, and I think you need to limit what you're demanding of witnesses in that context.
I had another question in that context. Do you have, so now that we have Zoom technology and PDF and highlighting of capabilities, kind of different than introducing exhibits that are just scanned and uploaded in PDF. Are you offended if for instance, the contract's 50 pages and I want to say on page 10, paragraph 20, and I already have it highlighted in yellow? Is that something that's allowable or not allowable, or should it only be highlighted during the trial? Do you have, what are your views on that?
Well, my first view on that is anything the lawyers agree to is fine with me. So the very first thing you need to do is say, here's this 50-page contract. The focus is on paragraph 10 on page 29. Do you mind, Joe, if I go ahead and highlight that for the witness so that we're not moving back and forth through this paper all the time? And if Joe says fine, then I'm fine with it. What I don't like is when you upload the document, it's already been highlighted, it has flags and tags and margin arrows, and then you're asking the witness, is there any paragraph in this contract that supports the proposition? And you've already got the arrow pointing to it and the highlighted pointing. Then the witness isn't testifying, you're testifying. So I would say try to get agreement of counsel on ways to handle that, and then don't use highlighting and arrows and magic wands and so forth to lead the witness. It's not appropriate to lead a witness any more than you could say, Mrs. Scriven, isn't it true that on paragraph 29 of the document gave you the authority to do that? That's a leading question. So pointing them out and asking them which paragraph is the other side of that same coin. Just to get agreement and to be careful that it's not leading, I guess it's a short answer.
Judge Delano, is that how you? Same.
I don't have a problem with that. And I agree with Judge Scriven. It needs to be discussed with the other attorney in advance. I don't like those open-ended questions where you ask someone, on the witness stand, or whether it's virtual or in the courtroom, what paragraph, supports their position. I mean, that's just a difficult question for anybody, particularly someone who's not a lawyer and not conversant with contracts and doesn't know how to look through the document. But I don't have a problem. And I've seen that on the screen share function where the paragraph is highlighted and enlarged so that everybody can read it more clearly. And that has been very helpful, I think. The one thing that I think attorneys really have to be aware of is during the trial, what they're really trying to do is create a record. And in some of the larger cases that I have handled where there was a lot of money in dispute, I'm just issuing a preliminary ruling. I know this case is going up on appeal. And I view my role at the trial, in addition to ruling on the merits, I view my role at the trial in helping the parties to make as good a record as possible so that when it gets up to the district court can figure out what's going on. So the one practice pointer I have for the attorneys is that when they're dealing with an exhibit that's 20, 30, 40, 50 pages long, and they're asking the witness specific questions about the exhibit, they need to identify the exhibit number and what page they're on, because no one looking at the transcript is going to know what the witness was talking about unless that page number is specifically identified. And sometimes an exhibit, the attorney's going back and forth between 3 or 4 different exhibits. And it's very unclear, I think, from reading a transcript, what exhibit the attorney was referring to. So all of you really be very careful and make sure that you are reciting the record accurately. One thing that has interested me in cases that I've had where the attorneys have been from the Southern District of Florida, they on the record announce every single docket number of every single paper that relates to that hearing. And we don't really need that to be done from my perspective because it's all on the docket to begin with. So to me, it's really not necessary. But I think that's sort of their perspective, is they want to make it very clear in the transcript what docket numbers are relevant to the hearing. And I'm not suggesting that our lawyers do that, but I am suggesting that our lawyers take that same philosophy as far as exhibit numbers and the pages of the exhibits are concerned, because it really is important to create that record.
Yeah, I'd like to follow up on that. I think that's an important point, and even take it going back a little bit. I think it's fundamental that a lawyer have their own methodology on how they are managing their exhibits. I mean, organization is such an important skill for purposes of trial. One thing I promise you, that no matter what judge you're in front of, you'll get a frustrated judge if you're up there fumbling through your exhibits because you're disorganized and you've lost the exhibit that you want to present. This is my own sensibility, my own opinion. I do want your exhibits electronically. I follow through. I annotate all the exhibits throughout the trial, whether it's a bench trial or even a jury trial. I keep them all. I have all my notes there. It's very simple for me to manage that way. I require that the parties, when they submit their exhibits, they submit them to me by exhibit number. I don't need a description of the exhibit, just whatever your exhibit number is that you intend to introduce it as is how I want it listed. So I know when I go back, I just need to go back to plaintiff's exhibit number 1 or defendant's exhibit 35. But I think it's important that you have some type of structure on your presentation of your witnesses. However you have that set up so that you're not looking, to somebody that's at counsel table with you, or you're asking for constant breaks so you can pull the exhibits. You need to be prepared, because that is one common mistake I see often in trials. Trials don't happen often anymore in federal court. So for lawyers, it's sometimes like riding a bike. You haven't been on a bike in a while. When you get on it, you're first a little wobbly, but then once you get your legs under you, you're doing okay. But there's some routine things like being organized that can really help your presentation, your preparation going forward in the case.
I would add to Judge Delano, I'm going to differ a little bit with Judge Delano here. As much as you can reiterate where the heck you are in the presentation of your case in bankruptcy court, the better you're going to be in the district court on appeal. Because I can tell you the cases that do come up on appeal are typically massive cases with years of litigation in them and massive records. And we spend an inordinate amount of time trying to figure out what the parties were referring to, because you all know what you're referring to. And when I get it on appeal, I have no idea. Sometimes I really just want to call the bankruptcy judge and say, what are you talking about here? Because the parties haven't said. I'm talking about docket 81, page 75. So more the better insofar as I'm concerned. And then in response to Judge Porcelli, I speak to my jurors often after trials. And if you are not an organized lawyer and you had to fumble through papers, he is exactly right. That's the one thing they talk about the most is she just didn't know how to get her documents right, or he didn't know where the documents were, and he was screaming at the paralegal like it was her fault. And so there's no invisible shield between your bench and the jury. And if you're being mean to your staff because you can't find out what you're doing, the jury is going to relate to your staff more than they're going to relate to you. So you have to be really careful and very organized.
So we have a great question from one of the participants, and I'll ask each judge, and we can end on this note. The question is, does the court have a position on use of PowerPoints in an evidentiary hearing where it is not run past opposing counsel beforehand? And I will start with the judge I'm most familiar with, Judge Delano.
Well, I'm thinking about this question. To me, the PowerPoint is sort of like a demonstrative aid. I did have a hearing once where an attorney brought a PowerPoint of his argument, and I announced in my ruling, I believe, that I never looked at it again because it was like it was another pleading practice, not a pleading, but it was like another filing on the docket, and the other attorney hadn't had a chance to look at it in advance. PowerPoints can be very helpful. It just depends upon the case. I would say once or twice I found a PowerPoint to be particularly helpful. What I don't find helpful, and from time to time people will come with the blow up poster boards, which I can't even see anyway, even if they put it right in front of the bench. I'm like, just print it out on a piece of paper and I'll hold it in front of me. So those I don't find helpful, but I would not use a PowerPoint unless I had circulated it to the other attorney in advance.
Judge
That's
Porcelli?
my thinking.
This goes back to Judge Scriven's comment earlier. In the end, I mean, if you're using a PowerPoint, you need to ask yourself, why wouldn't you show it to opposing counsel? All that should be in there is what is going to be of record anyways. You run the peril of an objection and then even an adverse ruling without sharing it with opposing counsel. Now, will I require it if it hasn't been used and shown? No, I'll hear what the argument is. But, most importantly, PowerPoints can be effective. I've had PowerPoints used both in simple discovery disputes and then even bench trials. And they can be very effective when done appropriately. But there's no need to put anything in there that's not already admitted into evidence. And so I don't need memes or, any animations. It's just simply if you're looking to highlight some document or piece of testimony, that's one way to organize it and present it through the use of a PowerPoint. That's much more effective than having you to demonstrate each exhibit each time. Outside of that, then there really should be no need for the PowerPoint.
I like PowerPoints if they are good summaries of what I am supposed to have just heard. And I can understand how a lawyer might not want to share essentially his or her closing argument with opposing counsel ahead of time. So if it's being used as sort of the closing argument in an evidentiary hearing. And you might be actually preparing it as the hearing is progressing. And at the end of the hearing, you'll say, you know, 3 witnesses testified to A, B, and C. Witness A said this, witness B said that, and you pull it up on a dynamic PowerPoint. I think it can be very effective. I tell people in bench trials that judges are people too. We like to be entertained, and we like the fancy PowerPoints and presentation materials instead of the dry 1, 2, 3 ABC. And so I think they're helpful. I would just say to Judge Porcelli's point, obviously it would be better if you could get approval of opposing counsel, but if you can't, or you don't want to, just be sure you're within, you're coloring in the lines. If it's not objectionable, if it's the record and you're prepared to support it, and it's an evidentiary hearing, not in front of a jury, then I say they are very effective. And I've got to look at it to overrule it. So then I've already seen it. So you win both ways. You look at it when you bring it, and you look at it when I look at it, and then you look at it if I keep it. So I think as long as you stay within the lines and you don't do anything inappropriate, they can be very effective tools.
Thank you. And we see Eric has popped up.
I popped up because it's 1:28, so we've only got a couple minutes left. I just wanted to thank everyone, our moderators, our judicial panel. We had, I think at one point, over 100 participants, which is, I think, a record turnout for any of these CLE luncheons. And it's so great to have both bar associations putting on joint events. It's so nice to hear perspectives from all 3 of the judges we deal with: magistrate judges, bankruptcy judges, U.S. district judges. Just a wealth of information, and I really appreciate the time that you all put into preparing for this program. This was a lot of work, so thank you to our moderators. Thank you to our judges. The CLE number, in case any of you all missed it, it is in the chat box, but it is 211-0277N, N as in Nancy. So hope you enjoyed the program. Be sure to get your CLE credit. We'll send out an email reminding everyone of the CLE number in case you didn't have a chance to write it down.
And Eric, I just want to thank Judge Porcelli and Judge Scriven. It's a special treat for our bankruptcy practitioners to get the viewpoints from the magistrate judges and a district judge, especially a district judge who hears our appeals. And as we've been going through the program, I've been scrolling off and on through the list of attendees. I think I know almost all of you. It is wonderful to kind of think we see you here today. And thank you all for being here. But special thanks to Judge Porcelli and Judge Scriven, and also to Dana and to Lara for preparing us well for this program.
Thank you for the invitation. I was glad.
Thank you.
Thank you all.